what the crime you were wrongly convicted for was?
Oh, I was originally charged with armed burglary, assault with a dangerous weapon, and assault with intention to rape.
Could you give us some background on what led you to be wrongfully convicted?
Basically, the number one thing I was wrongfully convicted of was over the identification issues. I turned myself in on the case. I was on, I heard that the cops were looking for me for the breaking into a house. I didn't have no clue about what the crime was, and I just heard somebody broke in the house. They were looking for me. It's fair to say that I was very shocked and upset when I heard the intent to rape charge.
Eyewitness misidentification is the greatest contributing factor to wrongful convictions, proven by DNA testing, playing a role in more than 70% of convictions overturned through DNA testing nationwide. Despite proof of the inaccuracy traditional eyewitnesses ID procedures, the traditional eyewitness identification remains among the most commonly used and most compelling evidence brought against criminal defendants.
Many of the issues with eyewitness misidentification are a result of poor lineup procedure. There are several ways to remove personal bias and improve eyewitness misidentification as a form of evidence. Detectives can employ the double-blind procedure, in which the administrator of the lineup does not know the identity of the suspect. It should also be made clear to the witness that the suspect may not be in the lineup. Having the witness articulate their level of confidence or using a computer to administrate the lineup are other ways of improving lineup procedure.
Misidentification isn't isolated to photo lineups. In 1993, the victim of the kidnapping and shooting saw Angel Echeverria in a barbershop and believed him to be one of the gunmen. Despite eyewitness identification being unreliable, this as well as other factors, Echeverria was in prison for 19 years.
One of the main reasons so many innocent citizens are convicted of crimes is prosecutorial misconduct. Prosecutorial misconduct can range from offering unacceptable evidence in court, suppressing evidence from the defense, encouraging deceit from witnesses, and prosecutorial bluffing.
What is the exact definition? It's an illegal act or failure to act on the part of a prosecutor. A prosecutor may have break the law, court rules, or code of ethics of law practice while working as a prosecuting attorney, especially an attempt to sway the jury to wrongly convict a defendant or to impose a harsher than appropriate punishment. Let me give you an example. Jack has been charged with killing his lover's husband. He has been denied having committed the crime throughout the investigation, claiming that he had briefly attended an out-of-town going-away party for a co-worker during the time the murder took place. Unfortunately, his attorney could find nobody who could specifically testify to having seen him at the party.
A couple of weeks before the trial, another attendee of the party realized that Jack appeared in the background of a couple of videos she had taken during the party. She turned this video evidence into the prosecutor's office, trusting that justice would be done.
The prosecuting attorney decides that the video is a little blurry and buries it deep in a file somewhere. Jack is ultimately convicted of murder. He may have been acquitted when the prosecutor disclosed the evidence to his attorney, as it would have at least brought reasonable doubt. This is an example of suppressing evidence from the defense.
Now that we've learned the consequences of prosecutorial misconduct, let's take a look at two real-life situations where an innocent person was wrongfully convicted. Get ready to meet Frederick Clay and Christopher Abernathy.
As a 16-year-old boy, Frederick Clay was convicted of murder. Even though he was a minor, he was tried as an adult. The murder of a cab driver changed his life forever. At 4 a.m., witnesses heard a commotion outside a housing project in Massachusetts. Shots were fired, and later, Jeffrey Bowahan was found dead after being shot 5 times in the head. Neil Sweat and Ben Brown were by the building, but told police that they had not seen anything. Later, Philippa Sweat, Neil's mother, told police she saw 3 men with leather jackets at the scene. Frederick Clay was picked out of the lineup by Philippa. Later, another man identified Clay as a gunman. He was quickly arrested and put to jail. He spent 38 years in jail, finally being exonerated on August 8, 2017.
Christopher Abernathy was an 18-year-old high school dropout when he was convicted of raping and stabbing a former classmate. The main factor that led to Abernathy's conviction? Prosecutorial misconduct. The story begins a year before the teenager was brought in for questioning, when Christina Hickey, a former classmate, was found dead behind a shopping mall after she had been missing for 2 days. Police picked Abernathy for questioning because an acquaintance, Alan Dennis, had told police that Abernathy confessed to killing the young girl. After nearly 2 days of intense interrogation, Abernathy stated that he committed the crime, but he immediately recanted his testimony, saying his only reason for signing his confession was that he was promised he could go home if he did. But it was too late. Abernathy was tried in court, and on January 15, 1987, he was convicted of first-degree murder, aggravated criminal sexual assault, and armed robbery. The only evidence used in court was Dennis's testimony. But what prosecutors and the jury didn't know is that police pressured Dennis to give this testimony and promised to go easy on him for unrelated charges he had and offered him $300 to buy clothes for court. This information had not been disclosed to Abernathy's defense attorney or to the jury. This is a classic case of prosecutorial misconduct. The fact that Dennis's testimony was the only evidence against Abernathy and the fact that it was completely false makes the case even worse. Years later, Abernathy's future started to look brighter. In 2014, after students from Northwestern University and attorney Lauren Kazenberg investigated the case, the Cook County Conviction Integrity Unit opened up Abernathy's case and conducted a DNA test.
We conducted extensive DNA testing on all available evidence in this case during the course of our investigation.
Abernathy's DNA did not match any of the DNA collected from the crime scene.
As a result of this testing, we now know that Mr. Abernathy is excluded for every article of evidence in which DNA was obtained in this case. To be clear, there is no DNA match that would link Mr. Abernathy to any piece of evidence in this case.
On February 11, 2015, the Conviction Integrity Unit requested that Abernathy's convictions be vacated. The motion was granted and the charges were dismissed. 28 years after he was convicted, Christopher Abernathy was finally a free man.
The definition of false confessions is when someone admits to doing a crime they really didn't do.
The impact case is when someone confesses to a crime. The jury normally sees this as an okay to go ahead and send them to jail without much investigation in the overall case.
The impact on the person's personal life is hard. Prison can affect you mentally and physically. Most people who are imprisoned for a large amount of time lose their house, their family, and often don't know how to get back on their feet.
38% of alleged crimes committed by people 18 years or younger involve false confessions, and 11% of crimes committed by adults involve false confessions.
Bad science and snitch testimony are two important factors as to why so many individuals are wrongly imprisoned in present-day United States. Bad science is faulty science or information that has been found through a misconducted experiment or false sources. There are multiple reasons for bad science: poor research, poorly designed experiments, misconduct by researchers, and accidental or deliberate misinterpretation of data. Faulty forensic science is the second leading factor of wrongful convictions. In 2009, a Mississippi jury convicted Christopher Brandon of killing his girlfriend's 15-month-old son. As tragic as it may sound, it was believed that he had fallen off the couch and hit his head. The state expert's witness, a medical examiner named Stephen Hain, testified that the child had shaken baby syndrome, otherwise known as SBS. The criteria that meets the signs of SBS can also be correlated to shortfalls, genetic conditions, and infections. Later on, scientists from various other universities returned to the case and found that what the other scientists had claimed was used from an outdated textbook from the 1990s. The baby had died from a short fall, not SBS. From there are moves being made to better this in the courtroom, but it is hard to target each and every scenario that bad science is involved in. Mostly, government groups are working to spread awareness and appoint more official forensic experts. With bad science being number 2, snitch testimony reigns as the leading cause of wrongful convictions in capital cases. It revolves around the main evidence against the defendant being testimony by a police or jailhouse informant who is commonly referred to as the snitch. Here's a general breakdown. Corruption has been seen to go hand in hand with snitch testimony. Jailhouse informants have played a role in 156 proven wrongful convictions in the United States, including DNA and non-DNA cases. The snitch system has been a staple for centuries, reportedly started in 18th century England. The snitch system arose in the United States in 1890 with a murder case in Manchester, Vermont. As to why people would jeopardize the lives of innocent men and women is incentive. Reduced charges or sentence reduction, special inmate privileges, financial compensation are all included as motivation. Alexandra Natapoff, quoted from a court in an NPR article, said it best. It's hard to imagine a greater inducement to fabricate than the promise of one's own liberty. Arguments have been made that the snitch system should be eliminated entirely from the courts. While there's no sign that sweeping reform will happen in the near future, I'll list some options that have been proven to be politically palatable. First is having snitches wired so that incriminating statements are electronically recorded for the sense of accountability. In addition, having law enforcement authorities be electronically recorded allows for dialogue for possible snitches and presenting such recordings to the defendant, again adding to additional transparency in cases. Having prosecutors disclose whether or not snitches have been compensated has also been proven to be important in all degrees, and it's actually been utilized in the Illinois General Assembly after its adoption in 2003. If we continue towards transparency and continue to pay attention to those who are struggling and the lives that are being impacted, then maybe one day freedom will be served and justice will be found once.
So what does your relationship with exonerees look like in your profession?
I get cases for wrongful conviction two ways. Incarcerated men will write to me and tell me their story and ask me to investigate their case, and I will make a decision about whether or not I'm going to do that. Or the Innocence Project will come to me and say, we would like to hire you. This person wrote to us, and we will fund your investigation. Probably a comfortable caseload is, 4, maybe 5 of them. Right now I have 16. We all got together in a room and we sat down and we presented our cases to our colleagues and we came up with a strategy.
In your experience, what have you observed to be the main effects of being wrongfully convicted on an exoneree, and why are these mental and emotional effects so harmful?
Well, I think that Massachusetts is a particularly resistant state. Law enforcement is very protective of their reputation. However, I think that eventually, it will come to be in all 50 states.
So how were you finally exonerated?
Out of the blue, right after I found out my dad got cancer, actually, he sent me a letter saying they changed the law. No attorney is going to give you a guarantee. They can't do it. There is no guarantees. But I've known this attorney for so long where he just said, his exact words was, I can't guarantee it, but I'm very confident in this. They finally released me, the judge let me go, and it's very hard to explain. 16 years of the world, basically. Everything's changed. The buildings have changed, streets have changed, people have changed. My first 10 years was behind glass. I couldn't even give anybody hugs or anything. There's a lot of guys in my position that are not doing as well as I am. The prison gives you $75 when you walk out of prison. That's it. And that's if you ask for it, because they don't just voluntarily give it to you. And if you have some money on your books, they don't give you nothing. Basically, it's, here's $75, there's the train station, have fun.
So how were you finally exonerated?
Out of the blue, right after I found out my dad got cancer, actually, he sent me a letter saying they changed the law. No attorney is going to give you a guarantee. They can't do it. There is no guarantees. But I've known this attorney for so long where he just said, his exact words was, I can't guarantee it, but I'm very confident in this. They finally released me, the judge let me go, and it's very hard to explain. 16 years of the world, basically. Everything's changed. The buildings have changed, streets have changed, people have changed. My first 10 years was behind glass. I couldn't even give anybody hugs or anything. There's a lot of guys in my position that are not doing as well as I am. The prison gives you $75 when you walk out of prison. That's it. And that's if you ask for it, because they don't just voluntarily give it to you. And if you have some money on your books, they don't give you nothing. Basically, it's, here's $75, there's the train station, have fun. they had me in their sights, they put a photo array of everybody that looked just like me. Not a description of the guy. Every single person in that photo array was similar to what I looked like.
It's an unconscious bias that we have. We will recognize a face, but we don't really remember where we recognize the face from, but that's the only...
Basically what the cops said to her was, if you don't pick somebody, the case can't go forward.
Recognize a face, but we don't really remember where we recognize the face from, but that's the only...
Basically what the cops said to her was, if you don't pick somebody, the case can't go forward.
Where the innocent defendant's legal counsel performed so ineffectively that it deprived the defendant of the constitutional right guaranteed by the Assistance of Counsel Clause of the Sixth Amendment to the United States Constitution. To prove they received ineffective assistance, a criminal defendant must show two things: resulting prejudice and deficient performance by counsel.
Ineffective assistance of counsel may also be a ground for voiding a waiver of the right to appeal that a defendant may have signed as part of a plea agreement with prosecutors. Many of the issues with ineffective assistance of counsel lies to the fault of the defense attorney. In many cases, defendants retain or are burdened with attorneys who lack the time, experience, or professional responsibility to zealously represent their clients. These causing factors result in failure to investigate an alibi defense, investigate prosecution, witnesses, enlist experts to challenge the prosecution's physical evidence, or even attend or stay awake for hearings.
A review of published appeals by the Innocence Project revealed that 54 of the first 255 DNA exonerees raised claims of ineffective assistance of counsel. In the overwhelming majority of these appeals, 81% of the courts rejected the claims. However, in 7 cases, courts agreed with appellants and found ineffective assistance of counsel, leading to reversals of convictions for 6 exonerees and new representation in 1 case. In 3 other cases, courts either determined that the actions or lack thereof of the counsel were harmless, or courts remanded the case to lower courts for further review.
One case where courts confirmed allegations of ineffective assistance of counsel is Jimmy Bromgard. Bromgard, court-appointed lawyer, failed to file an appeal after his conviction. The court's reasoning to agree to his appeal was that the defense counsel was inadequate by not filing appeals. In 1991, Bromgard was granted a new lawyer. His new lawyer filed subsequent appeals, but Bromgard did not find relief until DNA testing later exonerated him.
I'll never get an apology from them. I'll never get, oh, we messed up. I'm going to have to fight them like I did to all these years in prison to overturn my case, and they kept trying to bring me to court for a year afterwards, even though they had absolutely nothing on me. Nobody wants egg on their face, so they're never going to admit it, they're never going to apologize.
How old were your daughters?
At the time, they were 5 and 3.
Wow.